Hi, my name is Cody Carver. Today I'll be talking about the case Parents vs. Seattle. In this presentation, I'll discuss the facts as well as the relevance to the classroom and teachers. The admissions. Since certain high schools in the Seattle district often became oversubscribed when too many students chose them as their first choice, the district used a system of tiebreakers to decide which student would be admitted to the popular schools. The second most important tiebreaker was a racial factor intended to maintain racial diversity. So at this time in the Seattle School District, you could try to go to any of the 18 public schools, or public high schools in the district, which has 113 public schools altogether. The population was based off the racial demographics of any school's student body deviated by more than a predetermined number of percentage points from those of Seattle's total student population, which were approximately 40% white and 60% non-white. A non-profit group, Parents Involved in Community Schools, sued the district, arguing the racial tiebreaker violated the Equal Protection Act of the 14th Amendment, as well as the Civil Rights Act of 1964 and Washington state law. This was because they felt that the race tiebreaker at a particular school, either whites or non-whites, could be favored for admission, depending on which race would bring the racial balance closer to the goal they wanted, which caused a lot of issues to happen. The cases related to the Parents vs. Seattle case is the Grutter vs. Bollinger and the Grant vs. Bollinger cases. Through these cases, the Supreme Court made justifications on race in higher education. Under the Supreme Court's predecessors made because of these cases, the races must be directed towards a compelling government interest and must be narrowly tailored to that interest. After applying these precedents to the Parents vs. Seattle case, it was shown that the race-based tiebreaker did meet the narrowly tailored precedents. So, Seattle School District petitioned for a different ruling from a panel of 11 Ninth District judges in the Court of Appeals. This changed the outcome again. The panel upheld the race-based tiebreakers that were set in place to maintain racial diversity in Seattle high schools. The panel rules that the district had a propelling interest in maintaining racial diversity and that the tiebreaker was used in the proper way because the district did not imply quotas and considered race-neutral alternatives, and the tiebreaker didn't cause harm to any races and had an endpoint. Chief Justice John Roberts wrote in the precatory opinion that the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. Also, in a separate opinion concurring in the judgment, Justice Kennedy agreed that the district's use of race was unconstitutional, but stressed that public schools may sometimes consider race to ensure equal educational opportunity. This caused the school district to make changes to the tiebreaker plan by first looking at social, economic, and minority status that is based off the income of the student, parents, or legal guardian. This plan is still used to this day in Seattle and other districts based their diversity on. This case, Parents vs. Seattle, was relevant to diversity as it ended race-based school populations in Seattle as well as across the country. Some related cases on race-based issues were the cases Plessy v. Ferguson case in Louisiana in 1896, The Westminster v. Mendez case in 1947 in Orange County, California, and the Green v. County School Board of Kent County in 1968 in Virginia. The other cases related to the Parents v. Seattle cases are the Grutter v. Bollinger and the Grants v. Bollinger cases. As stated earlier, the precedents of these cases were used in the decision of the Parents v. Seattle case. When you think about racial diversity, it could be beneficial to the classroom as it helps build confidence and reduces prejudices in the students and adults, and just makes for a better school environment. But be careful how diversity is established in the student population. As I stated above, social, economic, and minority status, it is based off the income of the student's parents or legal guardians. When thinking of factors of diversity in the classroom, think more about language, culture, and gender, as this can help the classroom environment. In my conclusion, I feel that creating diversity in the school setting can be a great thing that has plenty of benefits. Just don't do what the Seattle School District did and be race-based. Hope you enjoyed learning about the Parents v. Seattle case.